Chapter 6. Trust Administration. Key Exam Issues. Questions involving trust administration generally require an analysis of the trustee's powers and duties. As you make your analysis, always keep in mind the terms and objectives of the trust. 1. Does the trustee have the power? When considering issues related to the trustee's powers, under the traditional view, you should first identify the source of the power the trustee seeks to exercise. I. Has the power been granted by terms of the trust itself? Be sure to consider not only the express terms, but also powers that may be implied through construction of the trust terms. Roman 2. If not, has the power been granted by statute, or may it be implied by law as being necessary or appropriate, or something even less strict to carrying out the trust purposes? Roman 3. If not, has the power been granted by unanimous action of all possible beneficiaries? See Chapter Roman 8. Under the modern view of the Third Restatement and UTC, your focus should be on whether the comprehensive powers implied by law are restricted by the terms of the trust or by a statute of the particular state. Remember that, when in doubt, court instructions may be sought for rulings on law or interpretation the trust, but not for decisions based on the trustee's business judgment. 2. Has the power been properly exercised? Once you have determined that the trustee has the power, consider whether the trustee I. Exercise the power in accordance with trust terms and purposes, and Roman 2. Exercise the power in accordance with general fiduciary standards, i.e., acting with care, skill, and caution, each of which has a different meaning, but together add up to prudence, loyalty, and impartiality. In particular, and in addition, A. Always look for violations of the strict duty of loyalty, e.g., watch for self-dealing or potential conflicts of interest, even when a trustee has acted in good faith. Also, watch for a violation of the duty of impartiality, e.g., inappropriately favoring income beneficiaries over remainder beneficiaries. B. Also look for improper delegation of duties. Consider, e.g., whether an HW a reasonably prudent person would delegate, and for failure to segregate or earmark trust property. C. In considering the duty to invest and make the trust property productive, do not overlook the duties to diversify and to consider a suitable risk-reward level, replacing the traditional view to avoid even careful speculation and excessive risk-taking. Be sure to scrutinize commingled investment devices, e.g., for loyalty issues, although these are not prohibited under modern principles. D. If it appears that a power was not properly exercised, check to see if the trustee may be protected by an exculpatory clause within the permissible limits of those clauses, or is expressly or implicitly authorized to do what would otherwise be prohibited. Look especially for possible estoppel of one or more of the beneficiaries based on their expressed or implied consent. 3. What is the trustee's liability? If the trustee has acted improperly, think about the remedies the beneficiaries may have. Consider other relief as well as damages, and the amount or extent of the trustee's liability in surcharge cases, especially when multiple breaches are involved. Other liability issues may concern A. Trustee's liability to third parties. Remember that under the traditional vanishing view, the trustee is, with narrow exceptions, personally liable to third parties for contracts and torts incurred, even in the proper course of trust administration, and even if the trustee is not at fault. However, if you find such liability, recall that protection is available under the deserving trustee's right of indemnification, although sometimes this is inadequate protection. The modern, especially statutory view, is that, in the absence of fault, suit and liability are against the trustee in a fiduciary or representative capacity, i.e., the trust estate, not the trustee personally, is liable. B. Liability of beneficiary and third party. Consider the possibility of beneficiary liability to the trustee or other beneficiaries of the trust and third party liability, especially in the absence of bona fide purchaser status. A. General responsibilities and authority of trustees. 1. Introduction 599. This chapter deals with the operation of a trust once it has been established, as it functions over time under the settler's plan. A. Powers, duties, and rights 600. The actions of trustees and beneficiaries are subject to the legal rules discussed in this chapter, and the powers, duties, and rights of these parties are based on these rules. B. Hofeldian Analysis 601. In a noted article first published in 1913, Professor Hofeld attempted to assign precise meanings to the terms power, duty, and right along with others as they apply generally to legal relationships among persons. Wesley N. Hofeld, Fundamental Legal Conceptions as Applied in Judicial Reasoning, 23 LLJ, 1913. Although Hofeldian analysis is useful in this field, as in others, courts and commentators in the law of trusts rarely use these terms with such attempted precision. This summary uses these terms in the customary manner of trust cases and literature. 2. Functions, preservation, and productivity of trust Res. 602. A trust is a fiduciary relationship with respect to specific property, and this is reflected in the functions of the trustee, which include A. Preservation 603. The trustee must work to preserve the trust res, which includes identifying, collecting, and segregating the subject matter, and safeguarding it while performing the other functions of the office of trustee during the course of administration. In the modern view, the duty of preservation includes the duty to make reasonable efforts to protect the purchasing power, i.e., the real value of the corpus, as well as the income stream from risks of inflation. B. Prod 1 Vidi 604. The trustee has, as a primary ongoing function of trust administration, the duty to make the trust property productive, involving an investment responsibility substantially broader than that, e.g., of an executor or an administrator of a decedent's estate. That is, in accordance with the terms of the trust and appropriate standards under trust fiduciary law. A trustee ordinarily must invest and manage trust funds to produce a return that includes a suitable degree of income, if there are current beneficiaries whose entitlements are measured by trust income. C. Impartiality 605. The duties of preservation and productivity necessarily implicate the duty of impartiality, which requires the trustee to balance the terms, purposes, and priorities of the particular trust in light of each beneficiary's interest. See Infra 620. A main feature of the duty of impartiality is to seek a balance between the duty to preserve the trust corpus while producing income, often competing concerns, a balance that is necessarily a reflection of trust terms and settler purposes and priorities. 3. Trust terms and sources of trustees' powers 606. A trustee must ascertain, understand, and follow the terms of the trust being administered, and must understand the powers of the office and their limitations. A trustee's powers and responsibilities are derived primarily from the trust instrument and the applicable law. A. Trust Instrument 607. A most important and flexible source of a trustee's powers is the trust instrument will or inter vivos writing or other admissible evidence of settler intentions. See Rest. 3D4 Defining terms of the trust. Of course, all trusts need not be in writing, and not all extrinsic evidence is admissible. The powers thus created are not only those that are valid and expressed by a settler, but also those that are implied by law or found by implication through construction of the trust provisions. B. Law 608. Another important source of the trust terms and the trustee's powers is the trust law itself. Trust powers may be conferred by statutes or judicial precedents, and have often been said by legislatures, courts, and commentators to include those powers that are necessary or appropriate to carry out the purposes of the trust, and not forbidden by its terms. See Rest. 2D 186. But a half-century later, experience, precedents, widespread legislation, and evolution of trust practice and drafting have led the third restatement and the UTC to adopt views that imply almost unlimited authority subject to the trustee's fiduciary duties. See Infra 625. See Rest. 3D 85. UTC 815. C. Court Instructions 609. Trust terms and trustee duties and powers, both those derived from the instrument and those derived from law, may be ascertained and clarified in many instances through court instructions. However, courts will not instruct trustees with respect to matters within the trustee's judgment, but will instruct, essentially, only on the parameters within which the trustee is to operate. D. Beneficiaries' Actions 610. The trustee's authority and obligations, including liabilities, may to some extent be affected by actions of the beneficiaries. Under appropriate circumstances, and when acting with unanimity, the beneficiaries may possess and exercise the power to amend and terminate the trust, and may thus alter the terms of the trust. See infra 953-980. In other circumstances, including by action of fewer than all of the beneficiaries, a beneficiary's participation in or informed consent to actions of the trustee may bar that beneficiary from remedies that would otherwise exist against the trustee. 4. Standards of Fiduciary Conduct 611. In accordance with certain fundamental standards of conduct, a trustee's duties are owed exclusively to the beneficiaries of the trust. These duties are enforceable by the beneficiaries, and violations may provide a basis for removal, surcharge, imposition of a constructive trust, and other appropriate remedies. The following are basic standards of fiduciary conduct. A. Duty to obey trust terms 612. A primary obligation of a trustee is to obey and carry out the terms of the trust. A trustee has a duty to ascertain the terms of the trust, a duty to implement those trust terms in accordance with the general standards discussed below, and a duty traditionally said to be an absolute duty not to misdeliver the trust property, i.e., to ascertain and deliver to the proper beneficiaries. The trustee also has a duty to comply with applicable law, except as permissibly modified by trust provision. These obligations are essentially personal to the trustee, who may delegate duties within certain limitations and with prudence. See infra 657. The trustee has an obligation to account to the beneficiaries for the trust property and for the performance of trust duties. B. Prudence Standards of Care, Skill, and Caution 613. Trust law requires that a trustee exercise reasonable care and skill in the performance of trust functions, and act with a degree of caution appropriate to the particular trust and the skills of the trustee. These terms, although regularly used together, are not redundant. 1. Care 614. Care refers to the required diligence and expenditure of effort, including acquiring information about and understanding the acts he undertakes, or is required to perform, e.g., selecting and managing investments. 2. Skill 615. Skill refers to the level of understanding and capability the law requires of a person who accepts the office of trustee. Someone who falls below the objective, impersonal standard set by the law, i.e., usually ordinary intelligence, had better not serve as a trustee, for he will be held to that standard. Note, however, that it is generally agreed that a trustee possessing or representing that he has greater than the required level of skill and more than ordinary facilities is under a duty, in a sense, simply an aspect of care, supra to exercise that higher level of capability. 3. Caution 616. Caution refers to the required element of conservatism. Unless greater risk is authorized by trust terms, the duty of caution normally prohibits a trustee from acting with the same freedom that she would have in managing her own property. Although courts have sometimes referred to the caution a prudent person would exercise in managing her own property, or some say in managing the property of others. Under the modern view, a trustee must act with a degree of conservatism appropriate to the purposes and circumstances of the particular trust, i.e., as a prudent person would manage like property for like purposes in like circumstances. See infra 684. What might be branded as speculation or excessive risk in some circumstances is not excessive risk in others. See Duty of Loyalty 617. It is often said that the highest duty of a trustee is the duty of loyalty. It has two primary aspects. 1. Conflict with trustees' interests 618. This duty of undivided loyalty requires that, under normal circumstances, in matters relating to the trust, the trustee's personal interests are to be subordinated to those of the beneficiaries. In fact, with limited exceptions, the trustee is flatly prohibited from any form of self-dealing, even if the transaction is reasonable and performed in good faith. Not only is a trustee forbidden to respond to a conflict of interests, but ordinarily a trustee is forbidden to have even a potential conflict of personal interests with those of the trust. See Infra 691 et seq. 2. Conflict with outside interests 619. This duty also requires the trustee to act solely in the interests of the beneficiaries and only to further purposes of the settlor, i.e., not to be influenced in decision-making for the trust by other outside interests, not merely those of the trustee personally. D. Duty of impartiality 620. Closely associated with the duty of loyalty is the duty of impartiality, which is an obligation to each of the beneficiaries. However, trust administration involves virtually unavoidable forms of conflict within the trustee's fiduciary obligations, because the interests of beneficiaries are almost inherently diverse and economically conflicting, e.g., certain investments will inevitably favor income beneficiaries over remainder beneficiaries or vice versa. The duty of impartiality attempts to reconcile these conflicting obligations. This, however, is not a duty to treat or weigh the interests of all beneficiaries equally. It requires a balancing that reflects the terms, purposes, and priorities of the particular trust, as distinct from bias or favoritism injected by the trustee personally. Exam tip. Remember that impartiality does not mean equality, i.e., don't assume that the interests of all beneficiaries have the same priority and weight in the trustee's balancing of those interests. Rather, the trustee must consider the terms, purposes, and priorities of the particular trust in balancing the beneficiaries' differing interests. B. Powers of the trustee. 1. Meaning and nature of trustee powers 621. The term power in this context refers to authority expressly or implicitly conferred upon the trustee by trust provision or by law, i.e., the acts the trustee may perform. A. Improper exercise of permissible power 622. Powers can be improperly exercised to perform wrongful but legally effective acts, e.g., a trustee's power to convey good title to trust property to a bona fide purchaser despite committing a breach of trust, or to make investments that violate the duty of prudence. Thus, a trustee may have power to perform a particular act, but nevertheless violate a duty in so doing, such as by acting negligently, unreasonably, or arbitrarily. 2. Powers generally 623. As previously noted, it has traditionally been said that a trustee has only such authority and powers as are conferred on him by express or implied provision of the trust instrument. Roman II conferred by statute or court decree, and Roman III implied fry law by virtue of being necessary or appropriate to carry out the purposes of the trust. This may literally be true even under the modern view, with a liberal interpretation of appropriate. But the third restatement and the UTC essentially recognize that a trustee has virtually unlimited powers of administration, except as denied by terms of the trust or an applicable statute, with their exercise subject to the trustee's fiduciary duties. A. Passive trust 624. It is possible for a trust to be established with the trustee having no powers. In that case, the trust is merely passive, with the trustee's only authority being to hold title to the trust res, and perhaps to convey title to establish the beneficial ownership. B. Implied powers 625. Even when no powers are expressly conferred by the trust instrument. If it appears that the settlor intended more than a passive trust, powers appropriate to implement the trust are implied by law. The trustee in such a case may petition the appropriate court for a clarification of his implied authority. Under appropriate circumstances, even a trustee whose powers are specified in the trust instrument may petition the court for a modification of express or implied powers. See Infra 981-994. 1. Power contrary to trust terms 626. A power will not be implied by operation of law if it is forbidden by or contrary to the terms of the trust. But even here, courts can confer an otherwise forbidden power under appropriate circumstances. See Infra 981. 3. What powers will be implied as appropriate? 627. In addition to those powers specified in the trust terms or by statute, appropriate powers will be implied if not otherwise forbidden. Rest. 2D 186. It is sometimes said that these implied powers are those that are either convenient or necessary to the accomplishment of the trust purposes. One view, now generally rejected, has stated this rule solely in terms of authority necessary or essential to carrying out the trust purposes, whatever verbal formulation is used by the courts of a particular state. These general statements tended to be crystallized, at least in earlier decisions, into rules about specific powers that are or are not implied. The modern tendency is to avoid arbitrary limitations on trustee powers and to focus instead on the manner of their exercise. Rest. 3D 70, 85. The powers that will be implied, not surprisingly, differ somewhat from state to state, and the appropriateness of a power may be affected by a trust's purposes. Caveat. The discussion that follows would be essentially irrelevant in a jurisdiction that follows the third restatement or that has legislation similar to the UTC. See Rest. 3D 85 CMTS, ACL, UTC 815, 816. A. Power of sale 628. Where the power to sell trust property is neither granted nor withheld by the terms of the trust, most courts today will quite readily imply such a power. It appears, however, that in some states a power to sell personal property is more readily implied than a power to sell real property and possibly unique chattels. 1. Power implied from trust language and purposes and nature of Res. 629. The appropriateness of an implied power of sale will depend on the character of the property and on the language and purposes of the trust, including whether there is any indication that particular assets of the trust are or are not to be turned over to the remainder beneficiaries on termination. The modern view sees this more as a question of propriety of exercise than as one of power. Rest. 3D 86. Example. A trust directed the trustee to divide and distribute the trust res among 72 different beneficiaries, but no power of sale was either expressly granted or withheld. The court concluded that the trustee had power to sell trust assets, inasmuch as the settlor would not likely have intended the properties themselves to have been apportioned among so many beneficiaries. Smith v. Mooney, 139A, 513 NJ, 1927. B. Power to lease 630. Assuming again that the power is not expressly, e.g., by a direction to not lease or implicitly withheld, a trustee normally has an implied power to lease properties of the trust estate. Proper exercise of the power would require that rental terms and periods be reasonable and appropriate to the purposes of the trust, and especially considering its probable duration. 1. Lease for a fixed term 631. Where the trust has a fixed term, e.g., for 25 years, or until X reaches age 21, the trustee would normally be limited to lease periods that do not extend beyond that term, unless the circumstances require otherwise, e.g., in order to obtain a suitable rental. In such a case, a trustee may be wise first to obtain instructions from the appropriate court. The outdated reason, sometimes given for this limitation, was that the trustee has a limited title, and thus ordinarily no power to convey a greater estate to another. But the limitation is properly a reflection of a general objective of distributing unencumbered ownership to the distributees on termination of the trust. A. Distinguish no fixed term 632. Where the trust has no fixed term, the trustee ordinarily may grant a lease that in fact lasts longer than the actual duration of the trust, as long as the lease period is reasonable in light of market circumstances and the trust's probable duration, usually the life of an individual or of the survivor of a group of beneficiaries. UTW Annotation. Power of trustee and court as regards term of lease of trust property. 61 ALR 1368 1929. Example. Suppose a trust is created for the lifetime of a designated beneficiary who is 52 years of age at the time of the proposed lease. The trustee gives tenant a lease on the property for a period of 10 years well within the beneficiary's life expectancy. But the beneficiary dies several months later. The lease is proper and the trustee cannot be surcharged. 1. Probable term of trust 633. If the trustee had made the lease for a term extending beyond the probable duration of the trust, at least absent reasonable justification for doing so, this action would be a violation of the duty of care owed to the remainder beneficiaries and a breach of trust. The trustee would therefore be liable to the beneficiary for any resulting loss. Nevertheless, the lease itself and the lessee's rights thereunder may well be upheld, unless it appeared that the lessee knew or had reason to know or under applicable law had a duty to inquire whether the lease extended beyond the probable trust term, in which case he could not claim the status of bona fide purchaser. C. Power to borrow and mortgage 634. Unless conferred by the terms of the trust. The traditional view is that a trustee generally has no implied power to borrow money on the credit of the trust estate or to mortgage or otherwise encumber trust properties. Rest. 2D 191. Consistent with modern practices of prudent fund managers, courts today are likely to find that such a power exists, but must be prudently exercised. Rest. 3D 86 CMT. D. 1. Rationale. Courts have hesitated to imply such powers because of the increased risks involved, especially in light of the traditional concepts of the caution required of trustees, and possibly also because of doubt that a settlor would intend to confer such authority. 2. Emergencies or other justifications 635. The purposes and circumstances of the trust may be such that it would be appropriate to imply such a power even under the more restrictive view. In case of doubt, the safe course would be to have a court authorize the trustee to borrow or mortgage as necessary to preserve the trust estate or to further its administration, if this is not inconsistent with the probable intention of the settlor. Compare Infra 981. D. Power to incur expenses 636. In the absence of express provision to the contrary in the trust instrument, courts imply that a trustee has power to incur reasonable expenses for the administration of the trust estate. Rest. 3D 88. 1. Improvements 637. This power normally includes the power to make improvements on trust properties where reasonably required for the preservation, use, or productivity of the trust estate. Where not appropriate to the circumstances and trust purposes, however, an improvement cannot be sustained and would probably constitute a breach of duty by the trustee. A. Investment standards applied 638. This power may be best viewed as an aspect of the trustee's power and duty to make investments, and the validity and propriety of the improvement should be judged by investment standards infra 745 and 756, including the duty to diversify inasmuch as an improvement tends to increase the concentration of the trust's holdings in a particular property. 2. Management expenses 639. In general, a trustee can incur such expenses as are appropriate to the management of the trust estate. Maintenance and making repairs, employing advisors as prudent, and hiring agents and employees to perform services that would be reasonable for the trustee not to perform personally. E. No implied power to invade Principle 640. In the absence of a trust provision or statute granting the power, a trustee has no power to invade the principle of the trust for the benefit of a life income beneficiary, even in response to the beneficiary's need. Although an occasional decision has found by construction a power of invasion implied not by law, but from the terms of the trust. See also discussion of deviation from trust distributive provisions. traditionally limited to mere acceleration of beneficiaries' indefeasibly vested rights. Infra 992. Exam tip. Keep in mind that the above rules on implied powers generally do not apply in a jurisdiction that follows the third restatement or has enacted the UTC or similar legislation, which recognize that a trustee has virtually unlimited powers of administration, including the powers to sell, lease, and encumber trust property, except as denied by the terms of the trust or an applicable statute. The focus of the discussion would then be upon the propriety of the trustee's conduct in exercising the power. 4. Imperative vs. Discretionary powers. 641. Most trust powers are permissive or discretionary in that the trustee is expected to use judgment as to whether and in what manner to exercise any particular power. If, however, the trustee is required to perform a particular act, e.g., the trustee is directed to distribute the sum of $1,000 monthly to X, or the trustee shall, within 1 year after B's death, sell that land of the trust estate used by Bass her residence. The power is said to be mandatory or imperative, i.e., the trustee must, in the absence of grounds for deviation, exercise the power, the only discretion being with respect to the reasonable and proper manner of performing the power, to the extent that is not also prescribed. A. Imperative powers. 1. Identification of imperative powers. 642. Whether a power is imperative depends not only on the wording used, but also on the court's interpretation of the settler's purpose or intention in creating the power. Example: a trust provision that authorized the trustee to make certain payments to a beneficiary was held an imperative duty to make such payments because of the settler's expressed purpose to assure certain provision for the beneficiary, to whom the indicated payments were essential. In Recar's estate, 176 Misc. 571 1941. 1. Enforcement of imperative powers. 643. Whenever a trust power is imperative, and the trustee fails or refuses to perform, a court of equity will, upon petition of an interested beneficiary, order the trustee to exercise the power in the manner required by the trust instrument in addition to the possibility of surcharge for harm done. B. Discretionary powers. Limited judicial review. 644. Even where a trust power is discretionary, however, a court will review its exercise or non-exercise to ascertain whether the trustee has abused his discretion in deciding whether and how to exercise that power. Waddling v. Waddling, 27 F2D 193 6th Sir. 1928. Ventura County Department of Child Support Services v. Brown, 117 Cal. App. 4th 144 2004. Wiedenmeyer v. Johnson, 254 2D 534 NJ. 1969. 1. Trustee's discretion. Not courts. 645. In the absence of abuse, a court will not substitute its judgment for that of the trustee, nor will it direct the trustee whether or how to exercise his discretion. E. Halbach, Problems of Discretion in Discretionary Trusts, 61 column. L. Rev. 14425 1961. A. Trustee's Petition for Instructions. 646. Also, unless there is uncertainty as to the terms of the power, e.g., meaning of stated guidelines or the relevance of a beneficiary's other resources. See Infra 651. Courts generally refuse to grant instructions to a trustee with respect to judgmental aspects of the exercise of a discretionary power. B. Review of trustee's actions. 647. Where a trustee has already acted, courts refuse to second-guess the trustee's actions in the absence of abuse, i.e., unless the power is shown to have been exercised unreasonably, in bad faith, or in a manner inconsistent with the terms or purposes of the discretion. The mere fact that the court would have decided the question differently is immaterial. Barnett Banks Trust Co. v. Hyman, 504 So. 2D 791 Flaw. 1987. In Re Sullivan's Will, 12 NW2D 148 Neb. 1943. Rest. 3D 87. 2. Grant of absolute discretion. Effect 648. Language such as absolute or sole and uncontrolled accompanying a grant of discretion does not wholly prevent judicial review. A court of equity will still intervene if the trustee has acted in bad faith or with a motive or state of mind not contemplated by the settlor, but according to some treatises and court dicta, not simply for acting unreasonably. Pollock v. Phillips, 411 SE 2D 242 W. Fa. 1991. The difference, however, may be essentially one of degree. Rest. 3D 87 CMT. D. Also, a trustee holding such a power may not arbitrarily refuse to make a decision. A court will compel some exercise of judgment. Camden Safe Deposit and Trust Co. v. Reed, 4A2D 10NJ, 1939. 3. Discretionary powers over distributions 649. A trustee is often given discretionary power to invade the trust corpus for a beneficiary, or to make discretionary distributions of income or principal. In the absence of careful drafting, these provisions present certain recurring constructional issues. A. Standards to be applied 650. If no standard for the exercise of such a power is stated, a court is likely to impose simply a general requirement of reasonableness. Roe v. Roe, 347 P2D 968 or 1959's support is generally said to mean the amount necessary to maintain the standard of living to which the beneficiary was accustomed at the time the trust was created, and thus usually is held to include the support of persons residing with the beneficiary. Language such as general welfare and happiness implies even broader distributive powers. Rest. 3D50. B. Consideration of other resources 651. Another frequently litigated issue in connection with such powers is whether a trustee, in applying a standard, should take into account the other resources available to the beneficiary, and if so, merely other income. In other words, is a trustee's refusal to invade based on the availability of other assets an abuse of discretion? Courts are split on this continuously troublesome issue. Compare in Re Estate of Lindgren, 885 P2D 1280 Mont. 1994. Other resources ignored. With Nations Bank v. Estate of Grandy, 450 SE2D 140 Va. 1994. Other resources considered. The third restatement provides that the inference is that the trustee is to consider the beneficiary's other resources, but has some discretion in the matter. Rest. 3D50 CMT. E. C. Henry Goodman, 7 Misc. 3D 893-25. Adopting the third restatement position. Exam tip. If you encounter an exam question in which a trustee fails or refuses to exercise a power, look to see whether the power in question is imperative or discretionary. If the power is imperative, a court will order the trustee to exercise the power in accordance with the terms of the trust. On the other hand, a discretionary power is subject to judicial review only for abuse of discretion, e.g., if the trustee arbitrarily or in bad faith fails to exercise the discretion. A court will likely intervene and compel some exercise of the power. 5. Who may exercise trust powers? A. Co-trustees 652. Where a private trust has several trustees serving together, they hold all trust powers jointly unless the instrument provides otherwise. In the absence of a statute c, e.g., UTC 703A or trust provision to the contrary, jointly held powers must be exercised by all of the trustees acting unanimously. Rest. 2D 194. But the third restatement provides that if there are 3 or more trustees, they act by majority vote. Rest. 3D 39 CMT. A noting that majority rule is the traditional rule for charitable trusts, and that most states now provide for majority rule in private trusts by statute. 1. Sale or transfer 653. An attempted sale or transfer of trust property with the consent of fewer than the required number of trustees passes no title, even to a bona fide purchaser, at least if the purchaser knows or should know that necessary trustees have not joined. Cox v. Kriebel, 185A, 770 Pa. 1936. Duty of care 654. Each co-trustee owes the beneficiaries a duty of prudent participation in administering the trust. Hence, each is liable to the beneficiaries for any losses resulting from his improper or negligent acts, including by failure to prevent or redress another's breach of trust, or by reason of improper delegation of duties to a co-trustee. In general, a trustee may validly delegate administrative powers to a co-trustee only, and perhaps today more narrowly than where delegation thereof to third persons would be permitted. See infra 657-660. However, even in these circumstances, an attempted delegation among trustees may be an improper division of responsibility. See infra 676-679. See rest 3D 81 CMT. CL UTC 703E. 3. Limitations on unanimity requirement 655. If a requirement of unanimity of action applies, it applies only to the exercise of powers within the framework of the trust's terms and operation. Thus, there is no requirement that co-trustees act jointly in litigation to surcharge or enjoin other co-trustees. It has also been held that the requirement does not apply to other litigation, although the rule is in doubt. E.g., if one trustee wishes to appeal a judgment affecting the trust and another wants to abide by it, the appeal might not be dismissed because the trustees disagree. Stanton v. Praise, 138 Cal. App. 2D 104 1955. The success of the appeal may but not necessarily will determine whether the trust bears the costs of the appeal. 4. Court order trustees deadlocked 656. If administration is stalled because the trustees are deadlocked on an action with respect to which a decision is needed, a court may direct the trustees or appoint a trustee ad idem with respect to the matter. The problem becomes J1 yen onic. A change of one or more trustees or the addition of a trustee may be appropriate. Exam tip. If your exam question involves co-trustees, remember that under the traditional view, joint powers must be exercised by unanimous agreement. But most states now provide by statute that any power vested in 3 or more trustees may be exercised by a majority of them, of course, under either view. If there are only 2 trustees, they must act unanimously. B. Delegation of powers to third persons agents 657. Not every act of trust administration has to be performed by the trustee personally. The trustee has power to employ agents and servants to perform various acts and exercise various of the powers conferred upon the trustee. Vigdor v. Nelson, 79 NE2D 288 Mass. 1948. 1. Duty not to delegate 658. It is often said that a trustee has a duty not to delegate powers and duties in the performance of the office of trustee. But this is merely a rule of caution against excessive or improper delegation. 2. Ministerial discretionary distinction 659. Cases often state that a trustee may delegate purely ministerial duties, but not discretionary powers. However, this does not accurately state the present law. See infra 660, 667. 3. Care in delegation 660. A more modern view is that a trustee may delegate to others the performance of acts or the exercise of powers, as long as such delegation is consistent with the general duties of care, skill, and caution owed to the beneficiaries in the administration of the trust, i.e., where a reasonably prudent owner of the same type of property and acting for objectives similar to those of the trust would employ assistance. See infra 756. Bojert, Trusts and Trustees 555. Rest. 3D 80-90. And see Uniform Prudent Investor Act, UPA 9 regarding investment actions, the earlier restatement language, perhaps still accepted in a few states, appears to be excessively restrictive, forbidding delegation of acts which the trustee can reasonably be required personally to perform, and of power to select investments. Rest. 2D 171 CMT. H. Where delegation is appropriate, the trustee must select, contract with, supervise or monitor, and instruct the agents with care. C. Successor trustees and personal powers 661. Unless the instrument or circumstances clearly indicate otherwise, powers granted to a trustee attached to the office and are not personal to the trustee originally named. Rest. 3D 852. Hence, the powers conferred upon a trustee or trustees originally named may be exercised by successor or substitute trustees. 1. Note: the mere fact that a power is discretionary, even if couched in terms of absolute discretion, does not show that the settlor intended the power to be personal to the original trustee. C. Duties of the trustee. 1. In general 662. In the administration of the trust estate, and in exercising the powers of that office, the trustee's conduct must conform to the rules and standards of trust law and to the requirements of the trust provisions. A. Authority 663. An initial question to be asked about the propriety of any particular action, proposed action, or type of investment is whether that action or investment is one that is authorized. Today, this will rarely present an issue other than one to construe a provision that might limit the trustee's powers. But however the issue may arise, court instructions are likely to be available. B. Fiduciary Standards 664. Assuming that the act or decision in question is authorized, i.e., that the trustee has the power to act, and thus the freedom to consider the particular matter. The next question in evaluating the trustee's conduct is whether the trustee's actions were consistent with fiduciary standards and the duties owed to the beneficiaries. 2. Duty to administer trust according to its terms 665. Upon accepting the fiduciary office, the trustee is under a duty to carry out the trust and to administer the trust estate in accordance with the terms of the trust and applicable law. Rest. 3D 76. UTC 801. A. Duty to perform personally. Question of delegation 666. As discussed briefly above supra. 657-660. A trustee is personally responsible for administration of the trust estate and may delegate only with prudence. However, a trustee is not required to perform every act of trust administration personally. She may employ agents and servants to perform various trust functions, as long as this does not violate the trustee's basic duty to the beneficiaries to administer the trust for them, i.e., according to a growing view, at least in matters of investment. A trustee may delegate provided she exercises prudence in deciding whether and how to delegate, regarding both the selection and supervision or monitoring of agents, and also in arranging the terms of the agency, e.g., duties, guidelines, compensation, etc. Thus, under this view, delegation is allowed to an extent and in a manner a reasonably prudent person would employ others to help in the same 6 circumstances. See Rest. 3D 80, UPA 9, UTC 807. But see Rest. 2D 171. Exam tip. Although a trustee may decline to accept the trusteeship, she may not accept the fiduciary office and then delegate the entire administration of the trust. On the other hand, she may delegate acts that would be unreasonable to require her to perform, e.g., mailing letters, even under the traditional view. Under the modern view, there is no clear-cut standard for judging when delegation is proper. Should you encounter an exam question that raises an issue of improper delegation, discuss the facts both under the traditional view and under the modern view, in terms of what a reasonably prudent person would do in like circumstances. 1. Ministerial vs. Discretionary functions 667. The trustee may certainly employ others to handle the ministerial functions of the trust. But, despite indications in dicta to the contrary, this is not the limit of the trustee's authority to delegate, even under the now dubiously restrictive Second Restatement view. Certainly, in situations in which it would be unreasonable under the relevant circumstances to expect the trustee to personally perform all discretionary functions and exercise all discretionary authority, the trustee may delegate. However, this should not be understood as permitting delegation only when it is necessary to do so. There may be many situations in which a trustee could prudently, and thus properly act either personally or through an agent without an abuse of fiduciary duty or discretion. This also assumes that the fiduciary fees and expenses are not unreasonable. A. Supervision of delegates required 668. Even where a function is purely ministerial, a trustee who delegates such a function to a third person still owes the beneficiaries the duty to exercise the diligence of a reasonably prudent person in doing so. Thus, she must exercise reasonable judgment in selecting and contracting with the individual or individuals in question, and, after they are hired, make reasonable efforts to supervise them in the performance of their duties, which may be satisfied in the modern view by prudent monitoring. Even in this undertaking, the usual fiduciary standards of care, skill, and caution must be met. GSG. Annotation. Liability of testamentary trustee, as affected by attempt to delegate powers. 50 ALR. 214 1927. B. Advice of others 669. Delegation of certain discretionary functions is not permitted, e.g., acting upon a beneficiary's request for invasion of principal, or possibly, in a few states, the making of investment decisions. Even then, a trustee may seek, and in some circumstances has a duty to seek the advice of lawyers, investment counselors, and others. Ultimately, however, the trustee must make non-delegible decisions herself. If she simply accepts and follows advice without understanding it, or without exercising independent judgment, liability will normally attach for any ensuing loss simply because of the improper delegation or abdication of duty, which in and of itself constitutes a breach of trust. Thus, liability probably attaches cases are few, even if, under other circumstances, the same ill-fated decision might not have led to liability had it been made by the trustee personally and with prudence. With respect to the making of investments, compare discussion of mutual funds, etc. Infra 771-780. C. Proper delegation of discretionary functions, 670. On the other hand, oftentimes delegation of discretionary function is proper. This assumes that it would be necessary or reasonable for a person engaged in like activities for like purposes to do so. Even under the modern view, delegation of powers to make discretionary distributions would, normally at least, be impermissible. The need for flexibility, however, can readily be seen in the context of the operation of a substantial unincorporated business and trust, and is often necessary given the varied qualifications of eligible trustees. Compare family members with professional fiduciaries and the variety of trust estates and purposes. 2. Liability for losses caused by acts of agents. A non-delegible duty, absolutely liable 671. If the duty is one that the trustee cannot properly delegate under the circumstances, but she delegates it nevertheless and a loss results, the trustee is absolutely liable to the beneficiaries in her individual capacity. Generally, in such a case, she is a guarantor of any loss growing out of the agent's performance. Even if the trustee was in other respects careful and acted in good faith, this result follows from the fact that the very act of delegation itself was forbidden or otherwise constituted a breach of trust. Mech v. Behrens, 252 p. 91 Wash. 1927. B. Proper delegation, not liable 672. If the duty is delegible and the trustee used reasonable care in deciding to make the delegation and in selecting, instructing, and supervising or monitoring the agent, but a loss nevertheless results because of the agent's acts of negligence, dishonesty, or other misconduct for which, incidentally, the agent would be liable, the trustee is not liable to the beneficiaries. Rest. 2D 225. Rest. 3D 80 CMT. G. UPJA 9C. UTC 807C. 1. Distinguish liability to third parties 673. If, under the same circumstances, delegible duty and reasonable care in delegating, an injury to a third person is caused by the agent's negligence, In most states, the trustee is ordinarily liable to the injured party for the resulting loss according to traditional doctrine under the doctrine of respondit superior c infra. 820-8024. Rest. 2D 264 under the modern view and most statutes today. The liability is not personal absent personal fault, but in the trustee's representative capacity. Even where personally liable, without breach of duty, the trustee is entitled to indemnification from the trust estate. If it is sufficient otherwise, the loss will fall on the trustee individually. 2. Independent contractors 674. Respondit superior applies only when the delegatee is an employee subject to the trustee's supervision and control. If the person is an independent contractor, respondit superior does not apply. Thus, an independent contractor's negligence would not ordinarily render the trustee personally liable, unless she, too, had been negligent in the matter. 3. Business management 675. Some authorities, especially with respect to the management of a business, and certainly an incorporated business and trust or other operation comparably broad in scope, have not used the doctrine of respondit superior to hold a non-negligent trustee liable to third parties. B. Duty with respect to other trustees. 2. Co-trustees 676. Where there are two or more co-trustees, each ordinarily is responsible for all functions in the administration of the entire trust, and each must use reasonable care to prevent a co-trustee from committing a breach of trust, and even must use reasonable care to recover any damages if the other does breach his duty. Rest. 3D 812. A. Duty to actively participate in administration 677. It is a breach of trust for a co-trustee to fail to exercise reasonable care with respect to the actions of another co-trustee in the management of the trust estate. Each trustee has a duty and a right to check the trust records and accounts, and to be familiar with trust affairs and activities, in order to guard against any improper acts or mismanagement by a co-trustee, as well as to discharge her own duty to participate in administration. Fox v. Tay, 89 Cal. 339 191. Rest. 3D 81 CMT. C. B. When delegation to other co-trustees permitted 678. It is also a breach of trust for one co-trustee to abandon to another the exercise of any major trust power. That is, except in cases of necessity, emergency, or other special circumstances, delegation to a co-trustee is permissible only to the extent expressly or implicitly authorized by the terms of the trust. Caldwell v. Graham, ADA, 839 MD, 1911. Rest. 3D 81 CMT, CL. C. Liability for breach of trust by co-trustees 679. A trustee is not an insurer of the honesty and performance of her co-trustees. Liability requires some showing that the former was negligent or otherwise at fault in failing to prevent, discover, or remedy the co-trustee's breach of trust. Cox v. Kriebel, Supra, 653. 2. Predecessor trustees 680. For various reasons, a successor trustee may be appointed. The question then is, what is a successor trustee's duty with respect to the acts of a prior trustee? A trustee is not liable for breaches of trust committed by a predecessor trustee unless I. She knew or should have known of the breach, had failed to take proper steps to compel redress of that prior breach, or Roman 2. She negligently failed to determine the amount of property that should have been turned over to her, or otherwise neglected to obtain an accounting for and delivery of the full trust estate from her predecessor. Rest. 2D 223. Rest. 3D 76 CMT. D. C. Duty under a directory provision 681. Occasionally, a trust instrument gives a third party power to control, including by veto, the action of the trustee in certain respects, e.g., in making a particular type of trust investment, or even trust investments generally, or in deciding to sell or retain certain assets. This is to be distinguished from a trust in which the trustee is merely instructed or authorized to seek and consider the advice of a third person, an advisor. The advice is not mandatory, and the trustee need not follow such advice. Under a directory provision, the trustee has an affirmative duty to follow valid instructions given by the third party, the director. Any deviation from those instructions is a breach of trust, unless it appears that the instructions themselves are given in bad faith or otherwise constitute a breach of trust. Rest. 3D75. 1. Director as fiduciary 682. Unless the power is held beneficially, the director acts in a fiduciary capacity, i.e., owes fiduciary duties in exercising the power conferred by the trust instrument. Thus, if a trustee must follow investment advice given by the director, and the director's instructions are to benefit others, the director owes fiduciary duties of prudence, loyalty, etc., and has potential liability in giving instructions. Note: Trust Advisors, 78 Harv. L. Rev. 1-2-30-1965. 2. Distinguished Personal Benefit 683. If the director is given the power of control solely for her own benefit, e.g., a power given to a widow to prevent the sale of residential real estate held in trust, fiduciary duties would not normally be owed. 3. Comment. The law is not altogether clear, but the trustee's responsibilities with respect to a director may be much the same as the trustee's responsibilities with respect to a co-trustee, in whom the trust terms vest controlling authority, i.e., to be watchful, to keep the director appropriately informed, to refuse to comply with directions constituting a breach of trust, and to seek relief subsequent to or in anticipation of such a breach. 3. Duty of prudence, standard of care, skill, and caution 684. The prevalent traditional view is probably that a trustee must exercise that degree of care, skill, and caution that a reasonably prudent person would exercise in dealing with her own property. The trustee is held to the standard of skill of an ordinarily intelligent individual regardless of whether she in fact personally possesses such skill. This abstract standard of skill sets a minimum the trustee must meet, and is not reduced because of this trustee's personal deficiencies. A. Property of others 685. Some courts have taken the position that the standard is that degree of care, skill, and caution that a reasonably prudent person would exercise in handling the affairs of or in dealing with property of others, as opposed to her own affairs or property. This is based on the theory that in dealing with one's own property, one may be speculative and casual, but that a reasonable individual would exercise greater caution and conservatism in handling the property of others. Finley v. Exchange Trust Co. ADP 2D 296 ACLA, 1938. The response of those who adhere to the standard of prudence in dealing with one's own property is that there is no need to differentiate. Reference to a prudent person sufficiently covers the point. 1. Modern View 686. The modern view of this debate is to refer to how a prudent person would act in light of the purposes, terms, and other circumstances of the trust. Rest. 3D 771. B. Trustees with Special Skills 687. Although the minimum standard is not lowered for a particular individual who lacks the requisite degree of skill, generally if a trustee possesses or holds herself out as possessing superior or special skills or knowledge, she is under a duty, i.e., care requires her to exercise such superior skills or ability. 1. Professional Fiduciary Trustee 688. A professional fiduciary, e.g., a bank or trust company, is generally held to a higher standard than a lay trustee. It must apply the skills, knowledge, and facilities ordinarily possessed by those engaged in the trust business. Estate of Beach, 15 Cal. 3D 623 1975. C. Effective Compensation 689. The duty of prudence applies and other fiduciary duties apply whether the trustee serves gratuitously or is paid for her services. It is generally said that the same standard of care applies in either event. In Re Butler's Trusts, 26 NW2D 204 Min. 1947. But C. Karen E. Box. Distinguishing Trustees and Protecting Beneficiaries. A response to Professor Leslie, 27 Cardozo L. Rev. 2753 2006, suggesting case holdings may not quite bear this out. D. Effective expert advice 690. The fact that the trustee has obtained and followed expert advice is persuasive, but not conclusive as to whether she complied with the basic standard of care in administering the trust. A trustee may have a duty in some situations to seek specialized or expert advice, but the question remains whether a reasonably prudent person would have found the particular expert qualified and would have acted upon the advice, and particularly whether the trustee may have shopped for advice that would support the trustee's desired course of conduct. 4. Duty of loyalty to beneficiaries 691. The trustee is under a duty of absolute loyalty to the beneficiaries. The trust must be administered solely for their benefit, and the trustee is not permitted to place herself in a position that foreseeably could create a conflict of interest. The trustee must scrupulously avoid any personal benefit other than appropriate compensation resulting from administration of the trust estate. Even good faith and the absence of personal advantage does not excuse a case of self-dealing. Rest. 3D78. A. Transactions with trust estates 692. Unless authorized by a trust provision, court order, or consent of all beneficiaries see infra 720-723. It is a violation of the trustee's duty of loyalty to the beneficiaries to engage personally in any financial transaction involving trust property. Thus, it is a breach of fiduciary duty for the trustee to buy any asset belonging to the trust, or to sell any of her personal assets to the trust. It is no defense, under the so-called no further inquiry rule, that the trustee acted in good faith, for fair consideration, and in the interest of the beneficiaries. Broder v. Conklin, 121 Cal. 282 1D 898. 1. Rationale. There is an inherent conflict of interest involved in self-dealing. The trustee's duty is to sell trust property at the highest possible price, and yet as a buyer she is motivated to buy at the lowest possible price. The inverse, of course, applies in selling her own property to the trust. The trustee would have an inherent, usually unfair advantage in proving her case or covering her tracks if good faith, etc., were an issue, especially given the disadvantages in time, access to information, and often competence of the beneficiaries, and the importance of their being able to rely on the trustee's loyalty in this most sensitive of fiduciary relationships. Compare the more relaxed corporate duty. Robert W. Hallgring. The Uniform Trustees Powers Act and the Basic Principles of Fiduciary Responsibility, 41 Wash. L. Rev. 801 1966. Business judgments are particularly difficult to second-guess in trust circumstances, so the assurance of judgment free of temptation is essential to beneficiary confidence. 2. Forced sales and auctions 693. This rule applies even when the trustee is a purchaser at a forced sale or auction, even if the trustee turns out to be the highest bidder at an auction. The very possibility of being a bidder creates a conflict of interest with respect to preparations for and stimulation of attendance at the auction. 3. Beneficiaries' remedies 694. Regardless of good faith or fairness in the terms of the transaction with the trust, such personal transactions by the trustee are a breach of trust and are voidable by a beneficiary in the absence of estoppel, which may arise as to a particular beneficiary even when consent of all is lacking. Because the transaction is voidable, the beneficiary is in a position either to affirm the transaction if it turns out to be advantageous, or to set it aside requiring restitution of, or for the money or property received by the trustee in the transaction. Restitution requires restoring the trust estate to the position it would have been in if the trust had been properly administered, or imposing a constructive trust on the trustee to trace and recover the property or its proceeds and profits therefrom. Thus, the trustee bears the risk of subsequent loss or depreciation in value of the property transferred to the trust estate by being forced to repurchase it. and yet also bears the risk of having to turn over to the trust any profits accruing on the property in her hands. Rest. 2D 206. Exam tip. When faced with a question involving a self-dealing trustee, remember that a trustee's good faith, fairness, or actual benefit to the trust is irrelevant. Rather, if a prohibited transaction takes place, the beneficiary may I affirm the transaction or Roman II set aside the transaction, recovering any profit made by the trustee. B. Transactions with beneficiaries 695. Although dealings with the beneficiaries individually are not flatly prohibited as dealings with the trust estate would be. See Supra 692-694. The trustee who has any dealings with the beneficiaries, whether personal transactions not involving trust property or fiduciary, e.g., obtaining consent regarding trust matters, owes a duty of utmost fairness and openness. This ordinarily requires a disclosure to the beneficiary of all relevant facts known to the trustee, and Roman II that the transaction be fair, e.g., for adequate consideration. Sometimes independent advice to the beneficiary is essential to the transaction, such as where the beneficiary had customarily relied on the trustee's expertise. Rest. 3D 783. 1. Presumption of unfairness 696. The burden of proving utmost fairness is always on the trustee, i.e., there is a presumption that the trustee has taken advantage, and it is incumbent upon her to disprove it. If she cannot, the beneficiary is entitled to have the transaction set aside. Herpelsheimer v. Michigan Trust Co. 246 NW. 81 Mich. 1933. 2. Trustee need not have initiated transaction 697. The same duty is owed whether the trustee approaches the beneficiary with a proposal or the beneficiary approaches the trustee. In Re Dingy's estate, 35A2D 577 Pa. 1944. C. Specific types of transactions. 1. Loans to trust estate 698. Generally, a trustee is not permitted to lend her personal funds to the trust. But if she does so, she cannot charge or retain interest on the loan. A. Exception protection of Trust 699. Where there is a legitimate need for cash in the trust estate, and other sources for obtaining a loan are not reasonably available, it has been held that the trustee may advance monies to the trust estate and may charge interest at a reasonable rate. See Bremen v. Central Hanover Bank and Trust Co. 47A2D10NJ. 1946. But in such cases, court instructions and authorizations are advisable. UTC 802H5 trustee may loan personal funds for the protection of the trust, if fair to the beneficiaries. 2. Borrowing from trust estate 700. It is improper for the trustee to borrow trust funds for her own use, even if she agrees to pay interest at the going rate. Rest. 3D 78 CMT. D. If the trustee does borrow from the trust. A. Any loss sustained in investing funds borrowed from the trust must be borne by the trustee. She remains liable to the beneficiaries for the full amount borrowed, plus interest at the legal or prevailing rate. Rest. 2D 205. B. On the other hand, any profit made by investing the borrowed funds belongs to the trust estate. City of Boston v. Dolan. 10 NE2D 275 Mass. 1937. 3. Accepting compensation from third person 701. A trustee violates fiduciary duties if she accepts any bonus, commission, or other benefit for herself from a third person for an act done in the administration of the trust. Rationale. The law seeks to remove any temptation for the trustee to serve an interest that is potentially adverse to the best interests of the beneficiaries. Magruder v. Drury, 235 U.S. 106 1914. Otherwise, the beneficiaries are deprived of the assurance of undivided loyalty that the law seeks to provide. Example. A trustee violates her fiduciary duty when she receives a commission for obtaining insurance for trust property, even though, ostensibly, The insurance was needed and was purchased for the lowest price available. Example. Likewise, it may be improper without court approval for a trustee to accept a salaried appointment as an officer of a corporation of which the trust is the controlling or significant shareholder. A. Rationale. This is because her interest in the compensated employment, added to her inevitable obligations to the corporation and its other stockholders, aggravates potentially conflicting interests and might also hamper her independent judgment in voting the shares held in the trust. Mangles v. Safe Deposit and Trust Co. 173A, 191 MD, 1934. B. Exception compensation for assuming corporate role 702. Under appropriate circumstances in discharging and advancing her duties to the trust estate, it may be beneficial to the trust, and thus proper, for a trustee to serve on the board of directors, and perhaps as an officer of a corporation in which the trust is a significant stockholder, even where separate compensation is paid for her services as director. Ordinarily, however, this should be authorized in advance by the court. C. Exception compensation for special services 703. Service as an officer or director of a corporation in which the trust has substantial holdings, without compensation by the corporation, may involve extra responsibilities and work that would justify additional compensation from the trust. Or when compensation is paid by the corporation, it is turned over to the trust, with reasonable additional compensation being paid to the trustee. 4. Self-employment 704. A question that frequently arises is whether the trustee is entitled to receive compensation for services rendered to the trust beyond those ordinarily required of a trustee. Rest. 3D 78 CMT, C5. A. Extension of trust duties 705. If the services are merely an extension of her normal trust duties, it is proper for her to render these services and to seek reasonable compensation from the trust estate for them. B. Not part of trust duties 706. If the services performed are not an aspect of the trustee's duties as such, it would normally constitute prohibited self-dealing for the trustee to engage herself for the rendering of the services or otherwise to contract with the trust. Example. A trustee, who is also an insurance agent, arranges insurance coverage for trust property through her own insurance agency. This is improper self-dealing. 1. Effect. In such cases, the trustee must account for any direct or indirect profit received, and the transaction may be voidable by the beneficiary. 2. Employing family members 707. The same rule should apply where the trustee employs her spouse, a relative, or some company in which she is financially interested to render the services in question. See Rest. 3D 78 CMT. L. The trustee is therefore liable for any resulting loss, cost, or extra expense to the trust estate, and she must account to the trust for any benefits, direct or indirect, received by her or any other impermissible employee. C. Employing self as attorney 708. Many courts have allowed a trustee who is also an attorney to render legal services to the trust estate as an extension of the normal duties of a trustee to support the trust. It is often said that a trustee with special skills is expected to use them. See Supra 687. Under this view, there is no breach of fiduciary duty in rendering the requisite legal services, especially if there are efficiency advantages in doing so. This may be particularly applicable to researching legal issues routinely arising in the course of administration, and to many petitions for court instructions. But the question is more in doubt if extensive services in litigation are required. The desirability of detached judgment is applicable to significant decisions about who should represent the trust. 1. Attorney's fees 709. Different courts have taken different positions with respect to compensation. Amounts paid for services rendered to the trust beyond those ordinarily required in the capacity of trustee is a matter for judicial scrutiny and discretion. A. Comment. This scrutiny may operate within a rule that primarily views such additional services either as a basis for extraordinary compensation in the role of trustee or as a basis for independent compensation as lawyer for the trustee. In either event, subject to a recognition of the probability that the trustee already acquainted with the affairs of the trust estate would be able to render the services more efficiently and inexpensively than outside counsel. This prospect of efficiency and economy is itself one of the possible justifications for permitting what might otherwise be forbidden as self-dealing. Exam tip. Although in many states the duty of loyalty does not strictly prohibit the trustee from receiving additional compensation from the trust for performing extra services for which she has a special competence, i.e., self-employment, keep in mind that the trustee is still under the normal duty to act with prudence and in the interest of the beneficiaries in determining whether the services are reasonably necessary and by whom they may best be provided, e.g., the trustee herself or a third person. D. Special problems of corporate trustees, 710. Certain problems of loyalty are specific to corporate trustees, usually banks and trust companies. 1. Trustees own shares as investments, 711. A bank or trust company cannot purchase its own shares as a means of investing trust funds, and ordinarily it cannot even retain such shares as a part of the trust estate entrusted to it by the settlor. Such purchase or retention, however, may be authorized expressly or implicitly by the terms of the trust, or as the result of the particular circumstances of the case. Rest. 3D 78 CMT. E2. 92 CMTS. C. D. A. Exception-specific bequest or inter vivos transfer, 712. Although a will leaving the general assets of a decedent, e.g., the residue or of all my estate, a trustee generally has not been deemed to be a sufficient basis for implying that the trustee may retain its own shares included in that bequest. A specific bequest of those shares or their inclusion among the assets transferred inter vivos to the trustee are special circumstances from which courts tend to infer an authority to retain the shares. 1. Note: a specific bequest is a gift of a particular item of property that is capable of being identified and distinguished from all other property in the testator's estate, and can be satisfied only by distribution of the specific asset, e.g., my 100 shares of Zeiss Co. stock. B. General Authorization, 713. Some courts, but certainly not all, have construed a general authorization in the instrument to sell or retain any asset of my estate as sufficient to authorize the trustee to retain its own shares as a trust investment. Robison v. Elston Bank and Trust Co. 48 NE2D 181 End. 1943. C. Voting of shares, 714. Some statutes authorize corporate trustees to retain their own shares received in trust from the settlor, but they are then frequently prohibited by statute from voting such shares absent specific authorization to do so in the trust terms. See, e.g., Cal. Fin. Code 11561. NY. Banking Law 60D127 Case law is divided on the question of voting these shares, e.g., if merely retention is authorized by the statute or trust instrument in the absence of an express provision. 2. Deposits in its own bank, 715. Similarly, the general rule is that a trustee bank cannot deposit trust funds in its own banking department. A. Statutes permitting, 716. Again, many states have statutes that authorize such deposits, usually up to a specified amount, and often conditioned on the trustee bank maintaining a separate account secured by government bond, etc., to cover trust funds on deposit. B. Interest, 717. Where such deposits are authorized, there is no breach of fiduciary duty as long as the trustee bank pays the prevailing rate of interest on the funds deposited. Any profits properly made by the trustee bank through the use of the deposited funds belong to the bank, not to the beneficiaries. Hayward v. Plant, 119A. 341 Con. 1923. 3. Commingled investment of trust funds, 718. where the corporation is trustee of two or more trusts, usually numerous. According to most modern authorities, it is not a breach of fiduciary duty to pool the funds from the several trusts in order to purchase common, i.e., shared investments, at least if practical considerations make this desirable. Identifiable shares or units of the common investment are then allocated to each trust. The use of common trust funds and the like as investment vehicles is discussed infra 771-780. A. Transactions among trusts 719. It is also not a breach of fiduciary duty for the shares in the common investment to be bought and sold among the various trusts participating in the arrangement, as long as the trustee acts in good faith and on a fair and reasonable basis, e.g., when cash is needed by one trust to make distributions while cash is available for investment in another. It is true that in handling purchases and sales between the trusts, the trustee is acting as both buyer and seller, but this is in its capacity as trustee, not as an individual, and is allowed under appropriate circumstances as a matter of efficiency and to facilitate diversified investment, especially for smaller funds. Hence, the transactions do not violate the trustee's fiduciary duties. First National Bank v. Basham, 191 So. 873 Allah, 1939. E. Exceptions to loyalty-based prohibitions 720. Prohibitions against divided loyalties by trustees are normally absolute. Thus, the only satisfactory defense against a charge of self-dealing is to be able to establish that the alleged transaction did not take place. There are, however, important exceptions that may apply in a particular situation. 1. Trust Terms 721. Conflicting interests may be authorized by the terms of the trust, either expressly, often narrowly, such as allowing a family trustee to purchase a trust asset, or by clear implication, e.g., where the settlor is aware that 'twill be a remainder beneficiary, and nevertheless names her as trustee, even though she will have power as trustee to invade principal for the life income beneficiary, and her investment decisions will inevitably involve conflicting interests. In such cases, a court will be attentive to others' concerns about potential abuses of the trustee's authority. 2. Court Authorization 722. Under appropriate, or at least compelling circumstances and subject to full disclosure and fairness, a court may authorize transactions otherwise prohibited by the duty of loyalty, such as the sale of a trust asset to the trustee at a higher price than otherwise available where there is a need or obligation for the trust to sell the property. 3. Beneficiaries' Consent 723. A trustee may be authorized to undertake otherwise prohibited transactions with the consent of all possible beneficiaries, as in the modification of the trust C infra 953-980. Or the trustee who acts improperly may be protected against surcharge by the consent or participation of particular beneficiaries. In the latter case, the prohibited conduct is not actually permissible, and the estoppel runs only against those beneficiaries who are deemed to have consented. In either case, whether some or all beneficiaries act, the action or acquiescence of the beneficiaries must have been based on fair play and full disclosure, which ought to include the beneficiary's understanding of their legal rights, the particular dangers present, and the available alternatives. Specific self-dealing rules. Pursuant to the duty of loyalty, a trustee generally cannot buy trust assets or sell her personal assets to the trust, even if the price is fair. Loan her personal funds to the trust, except for advances in urgent, short-term situations to protect the trust. Borrow trust funds for her own use, even if she agrees to pay interest. Personally gain through her position as trustee, i.e., cannot, with few exceptions, accept any bonus, commission, or other benefit from a third person. Employ herself, family members, or some company in which she is financially interested, except that a trustee who renders additional services to the trust may be entitled to extra compensation. Purchase or retain its own stock as a trust investment, unless authorized by the settlor, the court, or the beneficiaries. 5. Duty to collect and safeguard trust estate 724. In addition to the basic duty to administer the trust, every trustee has a duty to the beneficiaries to take and keep control of the trust property in accordance with the terms of the trust. Rest. 3D 76 CMT. D. A. Collection of assets 725. This ordinarily means that as soon as reasonably possible after accepting office, the trustee must take possession of the trust's land, tangible personal property, and the document representative of intangibles, stock certificates, savings account passbooks, etc. The duty to collect includes a duty to review the record of a prior fiduciary, e.g., executor or predecessor trustee, if applicable, and a duty to enforce all rights or claims of the trust against third parties. Any loss resulting from unnecessary delay in taking possession of the trust estate is chargeable to the trustee personally. In Re Klein's estate, 124A, 280 Pa, 1924. B. Preservation of assets, 726. The trustee is also under a duty to safeguard and preserve the trust estate. She must act as a reasonably prudent person would act in keeping her own, or some would say another's property safe from loss, deterioration, or waste, including of potential earnings. 1. Mandatory vs. Permissive List 753. The statutory or legal lists were generally of two types. I. Mandatory, a trustee was in breach of trust if he invested in anything else. And Roman II. Permissive, a trustee was not per se in breach of trust when he invested in something else, but he was taking his chances on being able to justify the investment in the face of a presumption against it. In Re Cook's Trust Estate, 171A, 730 Dell, 1934. 2. Standard of care and skill, still applicable, 754. Regardless of which approach a particular jurisdiction took, a trustee could not follow the list blindly, even though the type of investment was an approved one, and there was generally said to be a presumption in its favor. The particular investment made by the trustee could have been unreasonable under the particular circumstances, e.g., because of particular deficiencies in the investment itself, or because of lack of proper diversification of the fund, if proper care and skill were not exercised or the portfolio did not reflect a proper recognition of the trustee's duty of impartiality among the various beneficial interests. The trustee might have been held liable for an investment or set of investments on the applicable Stat 4 Tory list. In Re Randolph, 134 NYS, 17-1911. 4. Prudent Man Rule 755. By the late 20th century, nearly all states finally came to recognize, and perhaps several still follow, what has been traditionally called the Prudent Man Rule of trust investing. Under this approach, the trustee is held only to a standard of loyalty, impartiality, good faith, and prudence, requiring the exercise of care, skill, and caution in making trust investments. Over the years, this language has been codified in many states. In most of these states, the statute, if retained, has not been amended for modernization in making trust investments. However, subrules generally evolve to establish that certain categories of investments were or were not permissible for trust investing. As the rule has usually been stated, the trustee must invest as men of prudence would in managing their own affairs, not in regard to speculation, but in regard to the permanent disposition of their funds, considering the probable income, as well as the probable safety of the capital to be invested. Harvard College v. Amory, 9 Pick, Mass. 446 1D 830. 5. Modernized Prudent Investor Rule 756. What is now recognized as the Prudent Investor Rule originated in a preliminary volume to the current Third Restatement Project. That volume was published in 1992 as Sections 227-229, and as of 27, Incorporated Info the Third. Regular volume as Sections 90-92 Chapter 17, although the preliminary volume is still in many libraries. In 1994, the rule was promulgated for ease of codification in the Uniform Prudent Investor Act, UPIA. Nearly all states have enacted either the UPIA or other legislation codifying the rule, or have earlier statutes that now embody like principles. The rule emphasizes that no single investment or course of action is imprudent. Each decision is to be evaluated, not in isolation, but in the context of the trust portfolio as a part of an overall investment strategy, which should incorporate risk and return objectives reasonably suitable to the trust. The trustee must exercise reasonable care, skill, and caution and consider the purposes, terms, distribution requirements, and other circumstances of the trust. Rest. 3D90. A. Comment. The rule is a modern response to the prudent man rule's limitations and rigidities supra. What was decided in one case as a question of fact tends to be treated as a precedent establishing a rule of law. Scott on Trusts 227. In contrast, the prudent investor rule recognizes that there is broad diversity in the goals and beneficiary circumstances of different trusts, in the composition of different estates, and in the skills of trustees. Thus, it would be inappropriate for the law to attempt to prescribe some universal standard of acceptable overall risk for trusts, or even of risk characteristics for defining permissible investments and techniques. C. Standards under Rules of Prudence. 1. Protection of remainder beneficiaries 757. Under these rules, the trustee must consider the interests of the remainder beneficiaries' preservation of corpus, as well as the interest of life beneficiaries usually, but not always, income productivity. This duty properly includes some reasonable effort to protect capital, and also the income stream against loss of purchasing power through inflation. The law was in some doubt and little developed in this matter under the prudent man rule, but the prudent investor rule explicitly requires this effort under ordinary circumstances. 2. Prudence determined as of time of investment 758. Whether an investment decision is prudent depends on the circumstances at the time it was made. Foresight, not hindsight, is the test. Rest. 2D 227. Rest. 3D90 factors to be considered include whatever is relevant liquidity, risk of loss or volatility, role and other assets in the portfolio, tax implications, etc. 3. Imprudent investments may not be retained 759. Upon the trust's creation, the assets originally received inception assets are to be reviewed to see if they comply with the applicable investment rule. If some do not, revisions in the portfolio must be made as necessary. The prudent investor rule also requires the trustee to continually review the trust investment plan and holdings, and to make revisions as investments or strategies become imprudent or unsuitable to the trust's circumstances. The trustee ordinarily should not retain investments that would be improper to purchase for the particular trust, or that have become unsuitable to its strategy, except as different considerations, e.g., taxation of capital gains, might apply to purchase versus retention. Personal liability might result from improper retention of investments or for delaying action for an unreasonable time after the duty to adjust arose. Babbitt v. Fidelity Trust Co. 66A. Woolmean 76 NJ. 1907. 4. Diversification 760. A cardinal principle of prudent investment is diversification. Even though an investment is otherwise proper, it may be, in context, an improper investment for the trustee to make, because too large a portion of the trust assets are invested in it, or because, by reason of that investment, an unreasonably large portion of the trust estate has become concentrated in a single investment or in a single industry or type of investment. In Re Dickinson, 25 NE, 99 Mass. 1890, this duty has not been clearly established at common law in all states, however. Nor is there total agreement on the manner of its application, especially regarding what constitutes a justification for not diversifying. See Amory Cans for the Arts v. Ruth Lilly Charitable Remainder Annuity Trusts, 855 NE2D 592 End. 26 Effect of Retention Language. Wood v. U.S. Bank, 828 NE2D 1E72 Ohio 2005, Special circumstances exception. 5. Each individual investment considered 761. The generally recognized duty initially to analyze and then to continually review each individual trust investment may but should not be seen to clash with modern investment theory. Modern theory tends to call for 0N, an overall portfolio basis substantial diversification, targeting suitable levels of risks and return, compliance with a duty of impartiality, and prudent control of costs, e.g., management expenses, transaction costs, capital gain taxes in managing an investment program. A. Comment. There remains doubt about traditional trust law's acceptance of some aspects of what is sometimes a bit loosely called modern portfolio theory. C. in Re Bank of New York. 35 NY 2D 512 1974. J. Langbein and R. Posner. The Revolution in Trust Investment Law. 62 ABA. J. 887 1976. And of the use of index funds on which many well-informed investors, large and small, today rely to achieve broad diversification for both safe and efficient, i.e., low analysis and transaction cost investing, rather than relying on the selection of specific securities based on an individualized evaluation and judgment of each. The prudent investor rule seeks to eliminate doubt about the general acceptability of indexing, but seeks neither to establish nor rule out any particular theory or approach to investing by trustees. B. Trend toward viewing overall investment strategy. 762. In determining care, skill, and caution, traditional trust doctrine, under the prudent man rule, has not looked primarily to the composition of the trust investment portfolio as a whole, although this has not been irrelevant, particularly with respect to diversification and the trustee's duty of impartiality. Rather, it has looked at each particular investment and required that its selection not only conform to the general standards stated above, but also that it meet some abstractly permissible but unstated degree of risk, viewed in isolation and tending to fail to take into account either the needs, risk tolerance, and objectives of the particular trust, or the effects the investment in question may have on the risk level of the trust portfolio as a whole. The newer rule, properly understood, continues to judge individual decisions, but calls for them to be viewed in the context of other holdings and in terms of their role in an overall strategy. This view recognizes, e.g., that the addition of risky assets may by improving diversification reduce portfolio risk, while enhancing return expectations, and even that tactics often casually labeled speculative are used by skilled, prudent managers to lessen certain risks or to help cope with specific dilemmas. Thus, it is quite possible for a high-risk investment to be proper in context and as a part of an overall strategy of a type that is widely approved and followed by knowledgeable, careful, even conservative investors. C. Conduct, not performance, is crucial. 763. These various principles, however, do not mean that the trustee is a guarantor against all losses. The test of prudence, and thus of liability, is one of trustee conduct, and not of an investment's or a portfolio's performance. Thus, as long as investment decisions are proper, the trustee is not responsible for resulting losses. Performance matters, however, in measuring damages when a breach of trust occurs, and it is not, as some have suggested, a real obstacle to the use of modernized investment practices or portfolio concepts that a trustee cannot offset gains or profits obtained from some improper trust investments against losses from others, i.e., that she cannot view breaches of trust as a whole, reducing improper losses by improper gains. Again, that is a matter of measuring liability, not of determining the existence of a breach. D. Specific types of trust investments. 764. No one form or type of permissible investment is suitable for every trust and strategy. The fact that a particular investment is deemed proper in one case does not mean that it would be so in another. The trustee must always use independent judgment under the circumstances. Nevertheless, in applying the prudent man rule, many courts have reflected certain attitudes in dealing with various types of investments and have crystallized specific subrules or rules of thumb out of the facts of individual cases, and from the general standards of trust investment, especially the element of caution. Thus, there may still be an unfortunate tendency in some states to classify some types of investments or courses of conduct as imprudent per se. 1. Bonds and other forms of debt investment. A. Bonds 765. Government bonds, federal, state, or municipal and high-grade corporate bonds, whether secured or unsecured debentures, are almost always a proper type of trust investment. Individual investments from within this category must nevertheless be selected with appropriate care, skill, and prudence. Thus, a bond investment would normally have been branded improper under the prudent man rule if the bonds were selling at a substantial discount due to the issuer's risk of insolvency. Under the prudent investor rule, however, the informed decision to purchase such a risky bond because of its potential for high returns may not be imprudent in a given trust situation. Even non-risky bonds added to a portfolio may not fit the overall portfolio needs of a particular trust by excessive overall conservatism, e.g., or by violating the duty of impartiality in causing an imbalance unduly favoring the income beneficiary. B. Secured and unsecured loans, 766. Regardless of the financial status of the debtor, the making of an unsecured loan by the trust estate has generally been held to be improper and a breach of trust under the traditional prudent man doctrine. Cornett v. Cornett, 190 SW, 333 Mo. 1916. Even under this view, however, it should not be improper to invest in money market funds. First mortgages and first trust deeds are proper trust investments, if well secured, which many courts at one time or another have taken to mean that the debt secured must be less than 50% of the value of the property, a strikingly conservative and outmoded rule of thumb. Second mortgages or deeds of trust have generally been held to be improper trust investments and often a breach of duty per se under the prudent man rule. No such generalizations are appropriate under the prudent investor rule. 2. Corporate stocks, 767. Some statutory lists have excluded common stocks and maybe even preferred stock. Such investments are generally now permissible, however, in jurisdictions following the prudent man rule and are certainly permissible under the prudent investor rule. A. Case-by-case evaluation, 768. Whether a particular investment in corporate stock is proper must be determined on the basis of the particular purchase and the particular stock involved asset values, record of dividend payment, management of company, length of existence, etc. The prudent man approach generally precluded investing in unstable or developing companies, relatively new and unestablished enterprises. But modern principles recognize that certain types of investing, e.g., venture capital investing, involve potential for rewards that requires a case-by-case evaluation based on suitability to the particular trust's objectives, risk tolerance, and other circumstances of the beneficiaries and portfolio. Rest. 3D90 CMT, P, and C. Chase v. Pevere, 419 NE 2D 1358 Mass. 1981. Compare ERISA 404 Al. B. Mutual funds, 769. When stock investments are appropriate, the purchase of shares of a stock mutual fund, which in turn purchases corporate stocks, is likewise readily held to be proper, perhaps in all states today. In Reese's estate, 85 NE 2D 563 Ohio 1949. For a fuller discussion of this and related investment forms, see Infra 771-780. 3. Land 770. An investment in land for resale or profit is a prohibited form of speculation and violates the duty of caution under the traditional prudent man rule because of the risk of fluctuation in value and the difficulty of resale. An investment in land that is related to some other trust purpose, however, might be proper, e.g., land upon which an authorized business is to be conducted by the trust, land to be used as a capital investment for the production of rent, etc. The propriety of investing in land depends not only on the particular purposes and circumstances of the trust, but also on the local law, which has varied from state to state. In some states, land has been presumptively or ordinarily an improper investment, requiring persuasive indication of implied authority to the contrary in a particular case. In others, land is presumptively a permissible investment, as it would be under the prudent investor rule, to be judged under essentially the same flexible principles by which other permissible investments are judged, with particular attention paid to the special management challenges involved, risks of inefficient market pricing, and problems of diversification. 4. Common or commingled investment devices 771. Efficient, productive, and secure investment is often sought by trustees through arrangements that involve the pooling of investment funds from various trusts by professional or institutional trustees. An individual trustee's investment in regulated investment company shares, e.g., mutual funds, and the use of other pooling devices. Such investments have a variety of advantages, and yet they may pose some risks if the instrument is silent and the law of the jurisdiction involved is not settled. In all cases of proper investments of this type, however, it is incumbent upon the trustee to follow sound practices for earmarking the investment of each fund, with due consideration of the expense elements involved. A. Mortgage participations 772. Cases have been somewhat divided regarding the acceptability of permitting several trusts administered by a single trustee to invest together in mortgage participations, under which substantial sums are loaned to property owners in exchange for mortgages on their properties, with the trustee issuing certificates of participation in the mortgages to each of the trusts from which the funds have been invested. 1. Modern Law 773. The tendency of modern cases and legislation, and certainly the UPIA, is to support such arrangements largely because they permit greater diversification and greater efficiency than would be possible if a single fund were confined to investing altogether independently. Springfield Safe Deposit and Trust Co. v. First Unitarian Society, 200 NE, 541 Mass. 1936. 2. But note: a court may still object to such arrangements as involving the commingling of funds from various trusts without sufficient earmarking. However, the courts that permit these arrangements treat the separate certificates as satisfying the segregation and earmarking as well as independent marketability requirements. B. Common Trust Funds 774. Common trust funds are more or less similar to mortgage participation arrangements. Funds from several, usually many trusts administered by a bank trustee are pooled in making investments of types that would be individually proper. To earmark, certificates of participation or shares in the common fund are issued to each trust from which funds are drawn. 1. Modern Law 775. Modem cases uphold the use of common funds, and legislation, now in most jurisdictions, recognizes the propriety of their use, as do federal regulations in the case of national banks serving as trustees. 2. Note: many banks recently have been terminating their common funds and relying instead on proprietary mutual funds. Most recently, there has been a modest reversal of this trend of abandoning the common trust fund. By establishing proprietary mutual fund arrangements, banks may participate in the operation and management of a family of funds. They receive compensation from the funds for their services to those funds. In nearly all states, legislation, e.g., UTC 802F, authorizes this form of conflicting interest. But it, like any other authorized conflict, must not be abused. See Mutual Funds and Other Investment Pools 776. Like individual investors, trustees, especially non-professional trustees, frequently use counterparts of the common trust fund, but with various extra advantages by investing in outside mutual funds, shares of investment companies, real estate investment trusts, REITs, and other pooling arrangements. Such investment mechanisms may have a variety of purposes, and today there are mutual funds for almost every currently conceived need or purpose, e.g., for venture capital or for overseas investing, including in emerging markets, with or without indexing, plus specifically tax-managed funds. A trustee must choose a fund or funds appropriate to the trust's investment needs and purposes. Even so, there was a split of authority under the prudent man rule, with modern cases and legislation supporting such investments, as long as they are made on a prudent basis. D. Analysis regarding pooled investments 777. The traditional objections to mutual funds and the like have been based on the delegation of investment authority allegedly involved, and Roman II, the additional tier of expenses involved by having a layer of management and investment expenses, aside from those of the trustee. The responses to these objections are: 1. No improper delegation 778. Improper delegation is not involved because of the trustee's ability to sell and change these investments like any other. And the mutual fund manager's decision-making is not materially different from that of the management of any other entity in which investments might directly be made. 2. Additional costs avoided or limited 779. The alleged problem of additional fees and expenses can and should be taken care of under any proper use of such vehicles. For example, banks make no charge to the participating trusts for the operation of common trust funds, the only compensation being that received for the trusteeship, so that there is but one tier of fees and expenses. In the case of investment in mutual funds, and the like, assuming the management fees, any loads, and other cost elements of investing in the fund have been prudently considered by the trustee, much of the burden of investing has been alleviated, and the trustee's compensation should reflect this fact, although not necessarily by one-for-one offset. The trustee still has fund selection, asset allocation, and monitoring responsibilities. However, bank-sponsored legislation enacted in near all states authorizes banks to receive separate, and thus potentially additional, compensation for the operation of proprietary funds. 3. Advantages of pooled investments 780. These devices permit greater diversification, efficiency, and access to skill than could be achieved by independent investing by most trustees. D. Trustees' liabilities and beneficiaries' remedies. 1. Standing to enforce trust 781. If a trustee has breached a fiduciary duty, only the beneficiaries or a successor trustee, co-trustee, or guardian or other person acting on the beneficiary's behalf can complain. Outsiders have no standing to enforce the trust and cannot hold the trustee liable for duties that do not run to them. Even the settlor can complain only if he is also a beneficiary rest. 2D 200. Although this rule may be changing usually by statute, especially in the case of charitable trusts, see Supra 508. 2. Beneficiaries' remedies. A. Equitable relief. 1. Suit to enjoin or compel 782. The beneficiaries may institute suits to enjoin or instruct the trustee, or to compel proper performance of particular duties. 2. Suit to remove 783. In appropriate circumstances, e.g., serious or repeated breach, the beneficiaries may obtain a court order removing a trustee or one or more of several co-trustees, or may deny or reduce compensation for the period involved. 3. Constructive Trust 784. Where a trustee has misappropriated trust assets or used trust funds to acquire other property, the beneficiaries can enforce a constructive trust tracing the property and requiring it or its proceeds and the profits from the property to be used exclusively for the trust and its beneficiaries, or enforce an equitable lien on the property to secure a claim for damages. B. Damages 785. Where damages are sought by the beneficiaries, they generally have been measured by the following principles. See Rest. 2D 205 211. 1. In general 786. The trustee is personally liable to the trust estate or to the beneficiaries directly, depending upon the circumstances, for any loss or depreciation in value of the trust estate and loss of income resulting from his breach of trust, plus interest. A growing number of modern decisions have recognized losses in the trustee's failure as a result of making improper investments, e.g., by not diversifying or by excessive conservatism, including favoring the income beneficiary by investing excessively in bonds, to achieve the gains proper investments should have produced. See, e.g., Estate of Wilda, 708 A2D 273 Me. 1998. Baker Boyer National Bank v. Garver, 719 P2D 583 Wash. 1986. This recovery for lost profits is expressed as restoring the trust estate to what it would have been if properly administered. Rest. 3D Prudent Investor Rule 2112. 2. Failure to make property productive 787. A trustee has a duty to make the trust property reasonably productive. This term is usually used to refer to productivity of a reasonable amount of income, i.e., yield. But the duty in its broader, but less frequently used, sense includes total return, often just return, i.e., income plus other return, mainly in the form of appreciation in the market value of principal. A trustee who fails to make funds productive is liable to the adversely affected income beneficiaries and to the trust or its remainder beneficiaries. See generally supra, 786. 3. Improper investment 788. A trustee who does undertake to keep the property productive is nevertheless personally liable to the beneficiaries for losses resulting from any investment that is determined to be improper or imprudent under the principles stated above. In Re Fawkes's Estate, 252 NW, 160 Wise, 1934. A. Note. Competent beneficiaries who knowingly consent to a particular investment may be estopped to hold a trustee liable for their portions of any resulting losses. See Infra 802. And see discussion of principles generally precluding offset of gains against losses. Infra 790. 4. Losses to principal 789. Where improper investment or improper conduct has led to a diminution in the value of the trust principal, the trustee is liable along with other possible liabilities to make up that loss. Example: a $10,000 investment of trust funds in Exco stock is found to have been imprudent. It is now worth only $2,000. The trustee is liable traditionally for the $8,000. But what if the trustee has made other improper investments that have increased in value, e.g., the same trustee imprudently invested $10,000 in YCO stock, which is now worth $15,000. A. General rule: gain from improper investment cannot offset loss. 790. It is a primary principle of trustee liability that, where there are two distinct breaches of trust, the trustee cannot offset the profits from one against the losses on the other. Rest. 2D 213. The policy of the rule is to avoid temptation to recoup losses or to gamble the gains from an earlier breach by undertaking another. B. Exception: same breach of trust. 791. If, however, the gains and losses are attributable to the same breach of trust, absent aggravated circumstances, a court will allow the balancing of losses against gains from that transaction. C. Single breach vs. distinct breaches. 792. It is often very difficult to determine whether a particular situation involves more than a single breach of trust. Courts generally phrase the question in terms of ascertaining whether the breaches are severable or whether they are substantially separate and independent. Usually, two separate, imprudent, or otherwise improper investments are to be dealt with independently and without offset. The trustee is generally held liable for the loss on the investment that turned out badly, while the beneficiaries are allowed to retain the gain on the one that turned out well. But if the trustee made a single improper investment, part of which could be sold at a profit, while the other had to be sold at a loss, his liability is the net loss after deducting the gain. But when are a series or set of investments all part of one investment action? Factors to be considered in ascertaining the severability of breaches include whether the same or different portions of the trust res are involved, although this factor is not particularly supported by the policy underlying the rule. Whether the breaches arise out of the same or different transactions. or out of the same or different investment policy decisions, the length of time between the transactions, and the like. Rest. 2D 213 CMT. E. Rest. 3D Prudent Investor Rule 213 CMT. F. 5. Profits 793. A trustee is liable for any profit made by him personally through his breach of trust. The purpose of this rule is to remove any personal incentive a trustee might have to commit a breach of trust, even at an opportune time. Example: the trustee improperly borrows $10,000 from the trust and invests it. His successful investments go up in value to $100,000. The entire profit of $90,000 belongs to the trust. A. Identifiable profits 794. A trustee is liable for identifiable profits that would have been made by the trust estate, but for the breach. Example: a particular security that the trustee was directed to retain in the trust estate was improperly sold, but at its full value, and the proceeds were placed in a bank account. Subsequently, the stock, which had been sold for $20,000, has now increased in value to $50,000. The trustee is liable for this $30,000 in lost appreciation that should have accrued to the trust estate. In these facts, even under the traditional rule on damages. 6. Interest and earnings 795. The trustee is also chargeable with income lost net of income received as a result of the violation of fiduciary duty. Thus, he is, under appropriate circumstances, chargeable with interest at prevailing market or statutory rates on the sums owing to the beneficiaries or the trust estate from the time of the breach. Rest. 2D 207. Relief from liability. 1. Effect of Exculpatory Clause 796. The trust instrument may contain a provision to the effect that the trustee shall not be liable for errors of judgment or carelessness, nor for any breach of trust. Such exculpatory clauses are generally given effect by the courts within reasonable limits. W. Allen, Annotation, Validity, Construction, and Effect of Provision of Trust Instrument, Relieving Trustee from Duty to Account. 171 LR, 631 1947. A. Limited by Public Policy 797. The clause is not valid or effective insofar as it attempts to relieve liability for bad faith, intentional breach of trust, or gross negligence. Such a provision would be contrary to public policy. Tuttle v. Gilmore, 7A, 859 NJ. 1886. The word carelessness in the above exculpatory clause is thus in doubt, as negligence probably would not be. See infra 798. B. Narrowly construed 798. In most jurisdictions, however, exculpatory clauses are effective to relieve the trustee of liability for other types of breaches of duties or standards. But even then, courts tend to interpret such provisions narrowly, so that, in cases of doubt, the areas within which a trustee may avoid liability are limited. C. No effect on creditors 799. Exculpatory clauses apply to suits by beneficiaries, but not to the trustee's liability to creditors of the trust. See below. D. Not ale expansion of powers 800. An exculpatory clause does not expand the trustee's powers or authorize that which is otherwise impermissible under the terms of the trust. The clause merely relieves the trustee from liability for the impermissible acts. Thus, it would not protect third parties who are liable or who are required to make restitution for their dealings with the trust property. Nor does it assure the trustee compensation for services in connection with activities improperly undertaken. Warren v. Pazolt, 89 NE, 381 Mass. 99. If you encounter a clause in a trust instrument purporting to relieve the trustee from liability for breach of trust, remember that such exculpatory clauses are strictly construed, but are enforceable to the extent no bad faith, intentional breach, or recklessness is involved. 2. Consent of beneficiaries 801. Under appropriate circumstances, all of the beneficiaries may modify a trust. at least as long as a material purpose of the settlor is not thereby undermined. See infra 954, 965, 972. Such unanimous action can, in support of a trustee's otherwise impermissible acts, constitute an amendment of the trust, making the trustee's act authorized, if not intended to amend the trust to permit subsequent acts of the same type. The unanimous action serves to prevent all beneficiaries from surcharging the trustee, thus giving the trustee complete immunity from liability for that particular act. A. Consent of some beneficiaries. 802. Absent unanimous consent. The proper consent of some of the beneficiaries serves to estop those who consented, but will not impair the rights of other beneficiaries to sue the trustee. B. Consent. 803. Here, again, it is important to emphasize the full range of duties the trustee has to the beneficiaries. As a result of those duties, courts are cautious in finding an effective consent and require full disclosure by the trustee and a properly informed action by a beneficiary who understands the applicable rights and alternatives. In addition, some affirmative approval or active encouragement, inducement, or participation by the beneficiary may be required. Mere silence is usually not enough unless circumstances impose on the beneficiary a duty to speak. 3. Other instances of relief from liability. A. Lashes and statutes of limitation. 804. A trustee may be protected by the running of a statute of limitation or by lashes on the part of the beneficiaries. Because beneficiaries do not learn of a wrong for some time, the statutory time periodically does not begin to run during the existence of the relationship, and until the beneficiary is of age and knows or reasonably should know of the facts constituting the breach of duty. In some states, statutes of limitations are held inapplicable to equitable, and the barring old beneficiary's cause of action is a matter of lashes, a more flexible doctrine under which the circumstances as well as the beneficiary's awareness affect the length of time within which a suit must be brought. B. Effect of trustee's insolvency. 805. In general, a trustee's liability may be discharged in bankruptcy, but not with respect to losses caused by fraud, embezzlement, or other intentional misappropriation. Where a trustee with liability to the beneficiaries becomes insolvent, questions of priority that arise among the beneficiaries themselves. Although some earlier cases granted priority to those beneficiaries first entitled to distribution, e.g., income beneficiaries over remainder beneficiaries, the usual rule today is that all beneficiaries share pro rata in the available recovery. Essentially, this is accomplished by restoration of the funds recovered to the trust estate, and then ascertaining amounts owed to income beneficiaries or others to whom distribution should have been made, and Roman II amounts properly to be retained as principal. In the absence of a special basis for doing so, claims of trust beneficiaries are not given priority over other general creditors of the bankrupt trustee, although trust properties are not assets of the bankruptcy estate, because the trustee has only bare legal title. C. Equitable relief. 806. Traditional doctrine holds a trustee liable for a breach of trust, even where he acted with the best of intentions. There is, however, a tendency in some courts, and under some statutes, to consider, in mitigation, the trustee's good faith, diligence, and whether the loss was foreseeable, as well as what was reasonable to expect of the trustee, and thus possibly to limit, or even excuse liability. See Scott on Trusts. 205-2. E. Trustee's liability to third parties. 1. Contract liability. 807. Under traditional principles, a trustee as principal, rather than the trust estate, is acted properly in the performance of trust duties in making the contract. In such a case, a third party may proceed directly against the trustee in his representative, not personal capacity. A. Distinguish improper contract. 814. If, however, the contract was an improper one, e.g., exceeded powers, or was an imprudent exercise of power, the disclaimer is not effective. The trustee remains personally liable, and no action is permitted against the trust estate, except that if the trustee is insolvent, most courts would permit suit against the trust estate. probably for restitution limited to the value of any actual benefits received by it, in order to prevent unjust enrichment. But see infra 819. B. Waste 815. An otherwise valid disclaimer will not be effective where the trustee subsequently commits waste or wrongfully uses up the trust corpus, so that the trust res the creditor expected to reach is not available. A collateral promise is implied that the trustee will not improperly undermine the source of the creditor's payment. B. Statutes 816. Legislation in most states explicitly eliminates the personal liability of the trustee as principal. This has not resulted from statutes providing that the trustee is the general agent of the trust estate. Where the common law has been modified by statute, only the trust estate, i.e., the trustee in his fiduciary capacity, is liable on contracts properly executed by the trustee, if his status as trustee was known to the other party. C. Trustee's right of indemnification 817. The trustee's right of indemnification, under the traditional view for a proper and prudent contract in the course of administration, means that the trustee can either satisfy his personal liability directly from the trust estate exoneration or pay the creditor from his own funds and then obtain reimbursement from the trust estate. 1. Includes cost of defense 818. The trustee's right of indemnification from trust assets includes all costs reasonably incurred in defending suits against him by third parties, unless the suit arises out of a breach of duty or from some fault of the trustee. Note that a trustee usually may not charge the estate for attorney's fees in an unsuccessful attempt to defend a surcharge action brought by a beneficiary. 2. Creditor's rights 819. If the trustee is insolvent, it has been held that his right of indemnification can be reached via creditor's bill in equity or its current counterpart by the creditors to whom he is liable in the course of administration. The right of the creditor is derivative and thus subject to all defenses the trust or beneficiaries would have had, e.g., breach of trust in a suit directly by the trustee. Mason v. Pomeroy, 24 NE, 202 Mass. 1/890. To the extent the creditors had a direct action against the trust estate, see above. However, their rights are not derivative, and thus probably are not subject to offset for beneficiaries' claims against the trustee. 2. Tort liability 820. Again, under traditional common law, the trustee rather than the trust estate is personally liable for torts committed by the trustee or his agents in the course of administering the trust, with the trustee having a right of indemnification from the trust estate if he was not personally at fault. Rest. 2D 264. A. Trustee's right of indemnification 821. A trustee cannot indemnify himself from the trust estate for tort liability where he was personally at fault either for intentional or negligent torts. If not personally at fault, however, indemnity is allowed. In Re Estate of Lathers, 137 My C 2,221,930. 1. Where proper 822. Exoneration is allowed a trustee who is not personally at fault for I. Torts committed by agents selected and supervised with reasonable care to undertake duties that can properly be delegated. Roman II. Torts based on absolute liability. And Roman III. Torts committed by the trustee as a normal incident to the kind of activity in which the trustee is properly engaged, e.g., a trustee running a newspaper has been held not liable for inadvertent libel. 2. Where not proper 823. But indemnification is not proper where the loss resulted from the trustee's breach of duty, in which case the fact that some third party actually caused the harm or damage is immaterial. Example: the trustee, operating an apartment building in trust, fails to obtain liability insurance under circumstances that constitute a breach of duty. A visitor to the building falls under circumstances rendering the trustee personally liable for a janitor's negligence. The trustee is not entitled to indemnification because the loss should have been covered by liability insurance, for the lack of which the trustee is personally and ultimately liable. B. Charitable Trusts 824. The older cases held that trustees of charitable trusts were not personally liable for torts committed by agents selected with due care. McDonald v. Massachusetts General Hospital, 120 Mass. 432 1876 overruled by Colby v. Kearney Hospital, 254 NE 2D 407 Mass. 1969. But the modern trend of authority is contrary. Trustees of charitable trusts are liable to third parties to the same extent as trustees of private trusts, i.e., for torts committed by agents within the scope of their agency respondit superior, even when the agents were selected with due care. Myers v. Drozda, 141 NW2D 852 Neb. 1966. If a charitable institution, e.g., a hospital or college, is trustee, its directors or board of trustees are not the trustees, the institution is. F. Duties and liabilities of beneficiaries. 1. Beneficiaries' duties generally. A. No affirmative duties 825. Unless a beneficiary is also a trustee, or unless an obligation is imposed by provision of the trust in which she has expressly or implicitly accepted her interest. The beneficiary owes no affirmative fiduciary or other duties to the co-beneficiaries or to the trust estate. B. Duty regarding breach of trust 826. A beneficiary does, however, owe a duty as do third parties to other beneficiaries not to participate in a breach of trust by the trustee, and a duty not to profit by the trustee's breach. Rest. 2D 256. 1. Mere consent, not participation 827. The mere consent of a beneficiary to a trustee's breach of trust, e.g., consenting to a proposed investment that proves to be improper, does not constitute a participation in that breach. However, there may be a fine line between mere consent and participation. A beneficiary who induces a breach of trust has been a participant in it. 2. Liability of beneficiary 828. An innocent beneficiary who profits from a breach of trust but did not participate in it is liable only to the extent of the improper benefit, i.e., the unjust enrichment. A beneficiary who participates in a breach is liable not only to the extent of the improper benefit, but also for the damage to the trust estate or other beneficiaries. 3. Beneficiary's change of position 829. The liability of an innocent beneficiary who profits from a breach of trust, even a good faith mistake by the trustee, is based on the theory of unjust enrichment. If, however, the beneficiary has changed her position in reasonable reliance upon, for example, an overpayment or other improper distribution by the trustee, this is generally held to preclude recovery by the trustee or other beneficiaries who may nevertheless surcharge the trustee. C. No duty to indemnify trustee 830. A beneficiary has no duty to indemnify a trustee for liabilities incurred in the course of administration, even under circumstances in which the trustee is properly entitled to indemnification from the trust estate. Of course, if a beneficiary has contracted to do so, she may be held liable to the trustee. It also appears that such an obligation of indemnification may arise with respect to the beneficiary settlor of a trust created for business purposes. Scott on Trusts 249. 2. Remedies against beneficiary 831. Where a beneficiary has participated in or benefited from a breach of trust, the beneficiary may be held personally liable, as may the trustee, to the extent of the liabilities described above. A. Beneficiary's share impounded 832. Whether the beneficiary's liability is purely as beneficiary or in her role as trustee as well as beneficiary, her beneficial interest is subject to a lien or charge to ensure payment of that obligation. Benefits accruing to such a beneficiary are suspended and impounded until the trust estate has been restored or resulting obligations to other beneficiaries have been paid. 1. Rationale. This impounding is an application of the general equitable principle that one entitled to participate in a fund cannot receive its benefits without first discharging any obligations to the fund. B. Creditors and assignees of beneficiary 833. Suppose that, even before others learn of beneficiary B's participation in or liability as trustee for a breach of trust. B assigns her beneficial interest in the trust to a bona fide purchaser for value BFP, or a creditor of B attaches that interest. What are the rights and priorities of these third parties as against other beneficiaries or the trust estate? 1. General Rule 834. The general rule is that the BFP or creditor has no better status than B herself had at the time of the assignment. The interest is subject to a charge securing B's liabilities to the trust and its other beneficiaries for losses resulting from the breach of trust. 2. Rationale. The BFP doctrine, whereby a BFP cuts off pre-existing equities, is a rule applicable to the purchase of legal titles and is generally not applied absent a statutory basis to the purchase of equitable interests. Therefore, a purchaser and, a fortiori, a creditor does not cut off a prior lien on the beneficiary's interest to secure repayment of her obligations to the trust estate and other beneficiaries. 3. Note: some courts have applied the same rule, even where the breach of trust occurred after an assignment of the beneficial interest, on a theory of once a beneficiary's interest, always a beneficiary's interest. This overlooks the fact that, after the assignment, the original beneficiary is no longer the beneficiary the assignee is. Thus, the restatement position is contra to these cases, taking the position that a BFP should not suffer for losses and defalcations by B subsequent to the time of the assignment. Rest. 2D 257. And C. Scott on Trusts 257. Exam tip. Although a beneficiary generally does not owe any fiduciary duties to the trust or other beneficiaries, she does owe a duty not to participate in a breach of trust. If you encounter a fact pattern in which a beneficiary has participated in a breach of trust, e.g., by inducing the trustee to make an improper investment, she is personally liable for any loss incurred by the other beneficiaries as a result of the breach, and her beneficial interest is subject to a lien or charge for the amount of the loss incurred by the other beneficiaries. But remember, mere consent does not constitute participation. G. Liabilities of third parties. 1. Generally, and for breach of trust. A. Debts owed and acts adverse to trust 835. Where a third party is indebted to the trust estate, commits a tort with respect to the trust estate, or is in breach of a contractual obligation to the trust, the trustee, not the beneficiaries, has the right to maintain a suit against the third party for collection of the debt, or for damages or other appropriate relief. This right of the trustee, of course, passes to a successor trustee. If the trustee fails to enforce the trust's rights, the beneficiaries can bring a suit in equity against the trustee to compel her to perform her duties. Under modern principles, any one or more of the beneficiaries in such a situation can now maintain a suit against the third party by joining him as co-defendant with the trustee. Or if the trustee is not subject to the jurisdiction of the court, the beneficiaries can generally maintain a suit in equity directly against the third person without joining the trustee. B. Breach of trust third-party participation with Trustee 836. Under appropriate circumstances, a third party who participates with the trustee in the commission of a breach of trust is liable to the beneficiaries, or the obligation may run to the trust estate. The third party's liability is the result of an interference with the trust relationship, i.e., with the duties owed by the trustee to the beneficiaries, and thus the cause of action primarily belongs to the beneficiaries. Although the usual rule today also allows suit by the trustee, a co-trustee, or a successor trustee on behalf of the trust estate or beneficiaries. 1. Improper transfer 837. Third-party participation in a breach often involves a trustee's improper, maybe good faith transfer of trust property to the third party. The transferee's possible liabilities in this situation are discussed in FRA 841 at Sec. 2. Misapplication of funds 838. The third party's direct or indirect involvement with the trustee in a breach of trust may also take the form of the trustee's misapplication of funds paid or other property transferred into the trust by the third party. Under what circumstances is a third party liable in such cases? A. Notice 839. Essentially, the third party in this situation is liable for participation in the trustee's breach of trust only if, at the time the payment or transfer was made, the third party had notice of the trustee's intent to misapply the money or other property. B. No notice 840. If, however, the third party pays or transfers property to the trustee with no notice of any impropriety in the transaction or of the trustee's intention to misapply trust funds, there is no liability. Even if the third party knows of the existence of the trust, but has no notice that the trustee has wrongful intentions, the third party is not implicated in the trustee's wrongdoing. Exam tip. Remember that direct suits by the beneficiaries against third parties who are liable to the trust in contract or tort generally are not permitted. The trustee alone can sue. The modern view, however, allows derivative actions by the beneficiaries or possibly action by a trustee ad litem against third parties if the trustee unreasonably fails to sue the third party, or, perhaps, if the trustee participated in the breach. 2. Third party's acquisition of trust property 841. Of course, where a trustee improperly transfers trust property, the transferee is good title and has no liability to the trust estate or its beneficiaries except, of course, for contractual or other obligations incurred in consideration of the transfer. The present discussion is concerned with a situation in which the transfer constitutes, for one reason or another, a breach of trust on the part of the trustee. Questions then arise with respect to the rights and liabilities of the transferee. A. Donee 842. In such a case, if the transferee is a donee, even in good faith, and without notice, he does not take the property free of the beneficial interests and may be required to restore the property to the trust. B. Bona fide purchaser 843. If, however, the transferee is a BFP, the transferee takes good title to the property free of the beneficial interests and has no duty to restore the property to the trust estate or other liability to the beneficiaries. A bona fide purchaser takes free of latent equities, and in this situation, the bona fide purchaser doctrine has generally been applied even where the trust property transferred was itself an equitable interest held by the trustee as a part of the trust res. C. Purchaser, not bona fide 844. If the transferee is a purchaser, but is not bona fide, he, like the donee, takes subject to the beneficial interests and has a duty to restore the property to the trust estate. 1. Non-BFP 845. Clearly, a purchaser who knows that the trustee is committing a breach of trust is not a bona fide purchaser. However, the mere fact that the transferee knows of the trust, i.e., that the property is trust property, is not sufficient to deny him BFP status, unless he knows, or should know, that the trustee's transfer is in breach of trust. A. Knows or should know 846. The transferee is not a BFP, not only if he actually knows of the breach of trust, but also if, under the circumstances, he should know of the breach, or if, by reason of statute or otherwise, he is deemed to know, e.g., by having a duty to inquire, and thereby being charged with such knowledge as a reasonable inquiry would have produced. The laws of the several states differ with respect to the circumstances under which a party is under a duty of inquiry into the terms of the trust and into the circumstances surrounding the transaction when he knows or should know that he is dealing with a trustee.